Ready, start. Leave granted, full stop. Road rage results in disastrous consequences to both the perpetrator and the target, semicolon, as the present case demonstrates, comma, which resulted in the murder of one of the assailants and the arraignment of three who were targeted, comma, as accused for the murder, full stop. The appellant is the sole accused, out of the three, convicted for the offence under section 302 of the Indian Penal Code, 1860 and sentenced to undergo imprisonment for life and to pay fine of rupees 2000 within bracket rupees 2000 only bracket close with default clause of rigorous imprisonment for 2 months, if fine is not paid, full stop. The other two accused were acquitted, full stop. Of the two acquitted, semicolon, one was acquitted by the trial court and one by the appellate court, full stop. The state had challenged the acquittal by the trial court by way of an appeal, which also stood rejected by the impugned judgment, full stop. As of now, we are only concerned with the appellant herein who was convicted and sentenced for the offence of murder under section 302 of the IPC, full stop. At the admission stage, this court had issued a notice limited to the nature of the offence, semicolon, whether it falls under section 302 or section 304 of the IPC, full stop. We are, hence, confining ourselves to this aspect and the sentencing, if a lesser offence is made out, full stop. On facts, it is to be noticed that the deceased was riding a motorcycle in which his father was traveling pillion, full stop. Alongside the brother of the deceased was also riding a bike, semicolon, the three proceeding to a common destination, full stop. At a crossing, they saw a three-wheeler colliding with a scooter and the rider of the scooter falling down, full stop. The offending vehicle sped away while the father and sons approached the fallen scooterist, who told them that he had escaped without any injuries, full stop. At that moment, another scooterist also joined them, who was the colleague of the person involved in the accident, semicolon, both being lecturers in a nearby college, full stop. The scooterist wanted to pursue the offending vehicle and requested the father and sons to join them, full stop. Together, the five went after the vehicle and detected it at the crime scene, full stop. The scooterist and the father accosted the identified accused and questioned them on their conduct, full stop. It was the prosecution's case that while an altercation was going on, the appellant herein picked up an iron rod from his vehicle and hit the deceased on the head, full stop. After this, the three accused, who were in the three-wheeler, sped away and the injured was taken to the hospital, full stop. A DDR was registered immediately on the information supplied by the father, but no first information report was registered, full stop. An FIR was registered only after 5 days when the victim succumbed to the injury, full stop. The post-mortem report clearly indicates a homicidal death occasioned by the single injury inflicted on the head, full stop. The iron rod was recovered on the confessional statement of the appellant under section 27 of the Indian Evidence Act, 1872, full stop. We are not looking at the nitty gritty of the evidence, comma, since the limited adjudication possible is as to the nature of the crime, semicolon, whether it can be classified as a culpable homicide not amounting to murder under section 304 of the IPC, full stop.